Good afternoon, everybody. Good, dear colleagues, dear friends. It is an honor, a pleasure to be with you to introduce this fourth global digital encounter dedicated to intellectual property and advanced dispute resolution. Actually, the current crisis, the current pandemic, has created an upsurge of litigation on contracts, which of course were, for many of them, suffering breaches or are suffering breaches due to the current circumstances. This accelerates new use of arbitration and new trends in the field of arbitration for the trends that were already existing, more use of digital platforms, better development of research of neutrality of arbiters, and using new tools to this extent. Stronger role for WIPO in the IP arbitration mechanism. All these elements are accelerated by the current pandemic. The current encounter intends precisely to reflect on these issues, to fully brief you on the latest developments, and think together in the Q&A at the end of the encounter on the various options that may exist and that we will develop all together with the hundreds of participants who trust us.
I'm sorry, Laurent, your microphone has been turned off. We lost you back there.
Now, I would also wish to raise one essential point with all of you, which is the pleasure the Transatlantic Intellectual Property Academy and the Fide have to work together for the objective of sharing with all of you better knowledge on IP developments further to the crisis. And we would also wish to thank warmly all our sponsors of Fide and the Transatlantic Academy in this splendid operation, which puts together hundreds of people throughout the world, hundreds of academics, professionals, people interested in the field of IP. So I wouldn't wish to keep the floor too long. I would just wish to present briefly our speakers and moderator today. We have the honor to have with us Professor Catherine Rogers from Penn State University and Queen Mary London, so from the US and the UK, who also develops innovative tools for better quality of arbitration. Her role in IP arbitration and in developing the arbitration system throughout the world is worldwide acknowledged. We also have the major honor to have with us Chunyong Lam from Wong, Singapore, who supports strongly the development of worldwide arbitration, and both, of course, are arbitrators. And to moderate our debate today, we have one of the highest authorities in the world, with Ignacio de Castro from WIPO in Geneva. Ignacio de Castro is originally from Spain, but is the director of the online and on the arbitration resolution directorate of WIPO, and as such plays a key role on promoting arbitration and external relations connected to this. So we really have key colleagues to discuss the matter and to help thinking together. The idea is that the Fide Transatlantic Academy Global Encounters are occasions to think together to new solutions for the future, and also to build bridges and connections between all of us. This will be our last encounter before summer. The next one will be a big surprise. I shall announce it at the end. It's a scoop that I shall announce at the end of today's encounter. And it will take place, of course, in September after summer, and you will all receive communications for the few of you who will need to disconnect a bit earlier today. So big encouragement and a big thanks to our exceptional speakers. I would leave the floor now to Javier Fernandez Laschetti, who actually is our Fide partner and Fide key player in organizing this activity. So Javier Fernandez Laschetti, the floor is yours.
Thank you, Laurent. Very briefly, because I think that you are more interested on the speakers and the moderator than on me. Just to welcome you on board once again, just to remind you that we are very happy to have you here as participants, and to remind you that this is not just a bunch of webinars, but this is the creation of a community in which you will play an important role. Remind you that it's not only the webinars per se, but also the documents that were posted by the speakers, and all the documentation that will be posted and will be for you, will be at your disposal. Today, I'm very happy to have here very high-level specialists. Two of them are friends of mine from a long time ago, Chunyan and Ignacio. Catherine is a new friend, and I hope that you will enjoy a lot with that three true specialists on IP arbitration and mediation. And thank you very much for coming. That's all.
So Ignacio, the floor is yours, and will be yours to moderate until the end, where I will just make a small announcement on behalf of Javier and myself, of course.
Thank you very much, Laurent. Thank you, Javier. Good afternoon, everyone. I have a few slides to set the scene, and then I will be asking some questions to the speakers. My main job today is going to be to try to keep to the timetable. So going very quickly through the slides, just to set the scene. I mean, what we see at WIPO is the split of cases in the different areas of IP, traditionally patents, the highest share, software, ICT, second, followed by trademarks. We have then quite a number of commercial disputes, mostly distribution, franchising disputes, and then copyright in the traditional setting. And now we are seeing an increase in the area of digital copyright, where we are also conducting currently a survey, and we will have a report by the end of the year. One important feature of these disputes is the settlement rate, and you can see that in mediation is 70%, but even in arbitration we have more than 30% settlement rate. In the next slide we see the caseload. The caseload is continuously increasing, and even in this situation of the COVID, we are expecting still an increase this year. And one trend that I can already mention is, whereas traditionally we used to have mostly contractual disputes only, now we are seeing an increase in non-contractual disputes. In the next slide, we see that WIPO offers a number of online case administration tools. We've been doing this for a number of years. And of course, in the current situation, these tools are used almost in every single case. And now moving to the questions for the panel, we are going to start with, so we have 3-4 questions, depending on how well we are doing with time. The first question is for Catherine, also to continue setting the scene. And then Chungnam will answer the same question, is why use mediation and arbitration? And what are your views on how COVID has affected or is affecting the resolution of IP disputes? Catherine, please go ahead.
Right. Well, thank you for such a great introduction and for including me in this event, which I've been looking forward to because I've heard so much about the success of the earlier programs. To start with, I wanted to set the scene a little bit by saying, in many ways, arbitration was in a very good position, relatively speaking, for the current new normal with everything moving online. As we see from the slides that were just presented, WIPO has long had online arbitration, and the very nature of international arbitration, of the whole regime, is to essentially coordinate across national divides and in a sort of what's often described an a-national space, resolution of disputes that touch many different countries. And so it's almost sort of natural transition for international arbitration to accommodate the new online environment with COVID. It is a uniquely flexible process. So to the extent there need to be new rules about witnesses testifying by video, about online hearings, even if the arbitration agreement did not provide for it. The flexibility of the system itself makes it a very powerful tool for resolving disputes, even in this environment. And the entire system set up and organized mainly through the New York Convention, or the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards, itself functions to link together parties from different countries, arbitral institutions from different countries. The seat may be yet another country. It might be yet another country's national law that applies. And arbitration has historically brought these all together in single proceedings. And it's because of this flexibility and this ability to coordinate across borders that has made arbitration able to resolve disputes internationally, and also to relatively seamlessly translate to an online environment in the COVID crisis. And in fact, we are seeing that many court systems that have had, it's more difficult, and sometimes there are legal constraints for them to translate themselves or reinvent themselves online. We're seeing a lot of disputes that might otherwise go to courts, instead the parties agreeing to arbitration so that they can move forward. I think I'll stop there with a general overview, and then turn it back over to Ignacio.
Thank you, Catherine, for highlighting these initial points. Chung-Liam, maybe you could explain a little bit what you're seeing in terms of your practice in the current situation, and also perhaps make some references to the situation in Singapore.
Sure, Ignacio, and of course, thanks also to the organizers. I'm very honored indeed to be here, and good afternoon to everyone. I think, this very unique set of circumstances that we're suddenly finding ourselves in has really catalyzed and forced a lot of people to think about how it is that we're going to be resolving disputes. And already I'm seeing, for example, in the live Q&A, there was already a question asked as to whether or not there has been an increase in the use of arbitration because of the pandemic. I think the situation is real. We're in a very unique time. I think humankind has never experienced a situation where suddenly everybody has been asked to stay at home, and economies have just basically ground to a halt. And as a consequence of that, because economies have ground to a halt, you have situations where disputes are bound to arise. You will have situations where supply chains are disrupted, or where there are inabilities to kind of pay for goods and services that have been purchased on a certain kind of a premise of a certain volume of business. So I think, all of us would just need to think about the sort of a terrible situation that many airlines are in. Nobody would have expected that you would have a scenario where international travel would be disrupted to such an extent. And I'm quite sure if we were to ask ourselves even 6 months ago, whether or not we would be seeing ourselves in a webinar setting like this, I think the question might have been that might not have been necessarily an assumption. So the situation has suddenly forced upon us a very unique set of circumstances, and naturally giving rise to disputes. I've seen for myself, therefore, many clients asking questions about whether they can rely on things like force majeure clauses, whether or not the pandemic triggers a force majeure event as set forth in a lot of the agreements. You will have very difficult questions also being asked about whether I can get out of my contractual arrangements or get out of my license agreements that I've entered into because the commercial proposition has changed so much. And these are very real issues. I've also seen in the course of my work, say, technology development situations where projects have been delayed for the simple reason that a lot of the software houses are unable to marshal their resources together to deliver what it was that they were supposed to deliver in accordance with the contractually agreed timelines. So you can well see the real impact of the physical restrictions that have been imposed on humanity in general that have led to all of these disruptions, and correspondingly, you have an increase, an uptick in the number of disputes that naturally arise. And to your point, Catherine, I think arbitration and alternative dispute resolution generally, so arbitration, mediation, those are two very good examples of this whole suite of the possibilities of how people might resolve their disputes outside of the traditional court system. I think one of the key hallmarks of the ADR system is exactly the point of party autonomy, which I think you mentioned just now, the ability of parties who have a dispute to agree on a process or a means by which they can resolve their disputes. And that autonomy can extend to things like the procedural flexibility. You're not bound by the traditional rules of procedure or the usual dispute resolution processes that your national courts might impose on you. And I think that kind of flexibility naturally lends itself to these very odd circumstances, because the ability even, say, to have a hearing in physical courtrooms, that has been disrupted. Suddenly, in the case in Singapore, our courts basically only could hear urgent applications, a very, very limited number of applications in the immediate aftermath when we had to react and say, well, things might need to shut down a little bit, right? And then there was a mad scramble then to think about how we can do virtual hearings and stuff like that. So the ADR process definitely helps in allowing then for the tribunal to determine some of the rules in which we can continue to engage in hearings in these very odd circumstances, because the procedural rules can be made up and agreed between the parties.
Thank you, Chungnam. So let's move now to the second question, which focuses on technology. And I would like to ask you about your views and experience on the speed at which technology is being used as a tool in ADR. Also, whether you consider it's effective or there are certain limitations. And perhaps we follow the same order. Catherine, if you don't mind going first, please.
Thank you. So technology is a great topic that in many ways marries very well with international arbitration. Long before COVID, international arbitration had to invoke different forms of technology to be able to manage international disputes. So while online hearings were not really super popular before, certainly we've been talking about online dispute resolution for over a decade now. And it was promoted particularly for smaller disputes. And some people were reluctant because of the habit of traveling and in-person hearings. But the fact that it had been around for a long time, that there had been extensive discussions about how we might adapt to online hearings, I think made the transition, certainly to the COVID environment, much more seamless. Technology has also been used on a number of important bases for to do such things as, for example, manage document production. If you have hundreds of thousands of documents in a case, which is not in every international arbitration case, but certainly in some, you need technology to help you manage that. Technology has been used in general litigation, but also in international arbitration, in the presentation of evidence, in the coordination. We're increasingly seeing various online management tools to help the arbitrators manage the proceedings, to help the institutions interact with the arbitrators. And we are also seeing one of the other things that we are seeing, which is interesting, is the sort of dark side, I guess, of technology and online, which is we have been seeing cybersecurity issues arise. There's a new report out from the New York actually it's by the New York Bar Association, because for lawyers, there are a number of professional obligations that arise with regard to, in the European Union, with regard to protecting personal data, also with protecting your client's confidences. And I didn't mention in the last question, one of the reasons actually parties go to arbitration, international arbitration, for their IP disputes is in fact the ability to protect your confidences. In national court systems, depending on the system, there are different levels of confidentiality that are protected. So in the United States, actually, there's a constitutional right not only to access the court proceedings, the judicial proceedings, but also the court files. And combine that with document production, the requirement that you provide all sorts of information about the underlying dispute to the opposing party, and the dispute resolution process in courts can be a very high risk for disclosure of what's otherwise confidential information. When you transfer all that information to international arbitration, because the proceedings are confidential and not open to the public, and oftentimes, not always, but oftentimes there are also legal obligations to maintain it as confidential, you do have a much higher degree of confidentiality, but always subject to the risk of cyber hacking, which can be greater in international arbitration because of the coordination of multiple different sources, multiple different parties, essentially plugging in to the arbitration context. There have been a couple of very high-profile cases, including some involving governmental entities of governments being hacked and hacked data being introduced into proceedings, hacked information being introduced into proceedings as evidence. Sometimes it's admitted, sometimes it's excluded. There have also been some high-profile examples of hacking or cybersecurity breaches of arbitral institutions, including some very prominent ones. The arbitral institutions are just coming to grips fully, I think, with the concerns of cybersecurity as are parties around the world. But certainly, as everything has moved online to take advantage of technology, there's been an increased concern about the cyber technology protections. We have also, to sort of facilitate the new environment where we're relying much more on technology, there have been a number of initiatives, including the legal tech adoption in international arbitration, which is a working group that has published a draft of the protocol for online case management in international arbitration. There's a separate protocol by the Seoul Arbitral Institution, another by the ICC. I believe SEAC, and we'll hear about that probably, has come up with its own guide, Chartered Institute. In many ways, there's been a sort of race among different actors and varied institutions to come up with their own guidelines and best practices guidance about use of online information, online video conferencing to resolve international arbitration disputes. I think we're going to see some of those essentially materialize, solidify into more settled rules for how to conduct online hearings. The guidance will essentially, I think, be distilled into, for example, the next iteration of the IBA rules on the taking of evidence in international arbitration. IBA stands for the International Bar Association, which is a very well-respected, prolific, and important resource in setting different procedural trends and providing meaningful guidance. I think right there is where I will stop and turn it back to Ignacio.
Thank you, Catherine. Chung-Liam, do you want to answer the question, please, based on your experience?
Certainly, I think the circumstances have really forced a lot of us to embrace technology for lack of choice, to be honest. I mean, I look at myself, I've always been somebody who's been quite deeply involved in technology and so forth, but I've never brought myself to order my groceries online. I've always enjoyed the opportunity to go to a supermarket physically to go pick up the apples and oranges that I want to buy. But because of the circumstances that we're in, it has forced the adoption of technology. So it has always, to your point, Catherine, I fully agree. You know, it's always been this long debate about, well, we should do more online hearings, we should have a greater adoption of technology, but there was never this push, there was never this impetus to say, well, and let's get on with it, right? And suddenly out of the blue, we have to deal with this situation. Disputes need to be resolved, and we are forced to adopt these frameworks. Alongside that, though, there are very real risks. I think, Catherine, you've discussed quite a bit about the risks associated, say, with the security and the confidentiality of the hearings. But I think the issue around adopting this new norm of online hearing kind of even goes beyond those things. A lot of the things we take for granted, for example, I've got this backdrop behind me. You see the Singapore skyline. Clearly, it's a virtual background, but from a hearing perspective, there are real issues, because how are we to make sure that there is nobody else sitting in the room coaching a witness, for example, that's hidden from sight? How do you make sure that, okay, even if the person is not visible behind me, is there some way in which there is a prompter somewhere in front of the witness? So there are indeed a lot of issues that need to be grappled with when we start talking about moving into this new paradigm of having disputes resolved online, because we need to start casting our minds a little bit more broadly to think about, all of these nits and what ifs, and they do have an impact on ultimately the access and the fairness of natural justice principles and all those kinds of things. And it's important that it's addressed, because if those issues are not properly addressed, then even under the New York Convention, you could end up with a situation where your arbitral award is not enforceable, which is the nightmare that everyone would want to try to avoid. So to your point, certainly a large number of the arbitral institutions have responded to this situation. They've come out with protocol documents, they've come out even with template procedural orders. I think it's really important that people pay a little bit of attention to these documents, because it has taken some of the discussions that I'm sure many of the authors would have had in addressing some of these concerns, thinking about them. And as I've said, some of them may not be as obvious to us until you actually face a situation. And it's important to pay some attention to these aspects of things as well.
Thank you, Chung-Liam. I think those were very practical points. If I may go a little bit beyond my role as a moderator from the WIPO Center side, what we've done is, we were already kind of working quite a lot in the area of data protection, as was mentioned by Catherine, and we issued guidance. And now what we're seeing is that the issues of online virtual hearings, etc., are being raised and included in the first procedural orders invariably, and that's of course the practical way to deal with some of these issues. Luckily, we haven't had to deal yet with the issues of hacking, and I hope that WIPO's IT colleagues are quite used to dealing with PCT applications, and hopefully that makes us relatively safe. But let's move to the next topic 3, and we are doing quite well with time, I think. This one is a bit more complex. So it's question 3 is, what are the key recent developments, both legislative and soft law developments in IP ADR, including arbitrability and also if we get a chance to talk also about green arbitration, and perhaps we continue with the same order. Catherine, please.
Okay, thank you. Well, since I go first, I'm going to actually, we're talking about recent developments, but I'm going to talk a little bit about what's old is new. So WIPO actually, even back when I was in practice 20 years ago, had a great admiration for WIPO because it was really, I would say the only at the time certainly, and still the preeminent institution dedicated to intellectual property disputes. And they are in many ways unique from other types of disputes. One of the aspects that's unique is that intellectual property is property. And so you have this connotation of it being a right against the world, as opposed to arbitration, which is generally a private agreement between two parties. And so that's an interesting tension that exists. And in terms of a lot of the developments we're seeing now, and when we say recent, I think we'll talk what recent as in the last many years, it's been an effort to reconcile that sort of private aspect of dispute resolution and arbitration with the more public aspects of intellectual property. And that comes together most, I guess, intensively in questions of arbitrability that I think we'll get to in a little bit. But it's part of the whole development of how international arbitration and intellectual property have intersected generally. And I'm going to actually ask Ignacio to comment more specifically on some of the things that WIPO has been doing, because he's the one who can most authentically, and it's really such an essential part of what's been happening globally with regard to intellectual property. So I think one of the, I'm going to be a little more historic and leave kind of the more recent history to Cheng Niam. But historically there was some reluctance, I think I might say, for intellectual property disputes to be sent to arbitration. There were a couple of reasons for that. One was that you couldn't get interim relief, which oftentimes in intellectual property disputes is considered very important. You want not only to have an arbitration award 2 years, 3 years later that prevents continued use of licensed technology, but you want them to stop using that technology immediately when the dispute arises. And interim relief is a very difficult and complex issue in international arbitration because the emergency nature of it means it's difficult for arbitral institutions or arbitral tribunals to assure. In recent years, we've seen some really important developments. Again, when I say recent, I mean maybe more like a decade ago. We've seen revisions to the UNCITRAL model law, which is a law that many countries adopt with some reforms as their national arbitration law. And some of the most recent and significant amendments to the UNCITRAL model law was to facilitate interim relief, so that parties in arbitration could nevertheless go to local courts in model law jurisdictions and ask those courts to intervene immediately to protect, in this case, intellectual property while the arbitration is a little slower getting going. The reason interim relief is so difficult in international arbitration is that A, it can take many months to constitute the tribunal, which means you have to wait many months to get your urgent relief. And two, once the tribunal issues interim relief, until these recent revisions by UNCITRAL, what they rendered was an order or an award, but it's not self-enforcing. The parties might abide by it on their own, but if not, you have to go to courts, and courts were reluctant to enforce arbitral tribunal decisions on interim relief. The most recent innovation we've seen probably in the last 5 years is something called emergency arbitration. And that allows arbitral institutions to immediately appoint an emergency arbitrator before the formal arbitral tribunal is constituted. Many institutions have these rules. They can take anywhere from 24 hours to, I guess, upwards of a week to appoint this emergency arbitrator who renders an emergency arbitration award, oftentimes within a week or 2 weeks. And that is much closer, even if it still has to be enforced by a court, it's much closer in timeline and effectiveness to what parties were expecting. So that's one hurdle that was a source of reluctance for parties to go to arbitration that now I think arbitration in its flexibility and adaptation has overcome. Another, I think, reason why recent innovations has been also, in fact, protections and confidentiality, some greater clarity about when parties are not able to invoke national laws or draft their arbitration agreements to ensure confidentiality. And I think there's also been a number of other innovations that are that guide the performance and the conduct of the parties in arbitration that are soft law sources. And these are also things to pay attention to because they guide the conduct of the attorneys. If you're going to become an attorney in intellectual property international arbitration, you might have a different set of rules that apply to your conduct. There are a couple of different sources of that. There's the once again, the International Bar Association, IBA, guidelines on party representatives. There's also a new code by the Spanish arbitration group, there, which addresses a number of issues. There are a couple of new codes out for the conduct of arbitrators, most importantly, one by ICSID and UNCITRAL, that is still in draft form. All these forms of soft law become, I think, helpful to getting shared understanding among the arbitrators and parties. And counsel, as well as expert witnesses about what's expected. And those are some new soft law sources that if you're going to be involved in intellectual property international arbitration, you want to make sure you're paying attention to and are fully up to date on. With that, I think those might be my insights for most recent, and I'm going to turn it back over to Ignacio and Chanyam to continue.
Thank you, Catherine. The issue of interim relief and emergency proceedings is of course included in the WIPO arbitration rules. So it's articles 48 and 49. And the point that Catherine was mentioning, which is the possibility to request interim relief from the courts, is expressly provided in Article 48D. So that's something that we see from time to time. But Chung-Lian, please go ahead.
Absolutely, I think this issue about emergency relief it's an issue, of course, which has always been very much in the minds of particularly IP practitioners and clients in the field where they're dealing with technology, for the reason that interim relief is so much a part of the very real set of types of remedies that parties would look for. First of all, the ability to resort to the court system for that interim relief as a kind of a national law kind of reservation or acceptance on the one hand, and the subsequent innovation of the idea of emergency relief, emergency arbitrations. I think, interestingly enough, I think SIAC was one of the first arbitral institutions to have come up with that idea, and then that idea caught on with the ICC and a bunch of other institutions. And the point more generally that Ignacio was making, right, that the availability of some of these procedural rules, it underscores the importance of a familiarity with the set of arbitration rules that the parties are adopting. And to be honest, in the context of IP-related disputes, the WIPO arbitration rules are indeed a very rich source of rules that have been specifically developed to address the sorts of issues that are very unique to arbitration and intellectual property related disputes. And of course, Ignacio, you might be a little bit modest about saying too much about the WIPO arbitration rules, but emergency relief is just one aspect of it. The WIPO arbitration rules, they address questions or procedural points around how do we conduct experiments? How do we address site visits or primers, models, right? What about procedures to address disclosures of trade secrets and confidential information? I think it's so critical as part of this whole wider idea of party autonomy that when parties choose the rules, that they also bear in mind the sorts of particular institutional rules that they choose to adopt to spare themselves a lot of the pain of having to figure these out if this was indeed to be an entirely ad hoc kind of arbitration. So I think it's important to not just talk about the adoption of arbitration per se as a kind of dispute resolution process, but also be thinking about the institutions that would be best able to assist. And the issue honestly goes also to some degree of complexity. The law of the seat of the arbitration also has effects on the outcomes and the sorts of rules that would apply in relation to the arbitral award and so forth. Again, I think this is where some attention ought to be paid when parties agree to the arbitration clauses, and it goes into part and parcel of the sorts of decisions that have to be taken into account when deciding to go down this path. That said, though, I think you alluded to issues like arbitrability, and indeed, I do note from some of the questions from the floor, relating to the interface between, say, a patent, a finding of validity of a patent in the national courts, and how is this going to square with an arbitral award? And this is an area which has seen a lot of development in the last few years, because I think more and more people are starting to grapple with exactly this very fundamental question. We all know that if an attempt is made to invalidate a patent in a national court, that ruling or that finding of that court is going to be an in rem decision. It is going to be binding on the world at large, and that is because of the powers conferred in the national court or on the national court in making an in rem finding. But the thing about arbitral awards is that that's typically an award that just binds the two parties that have agreed to submit their dispute to arbitration, and therefore it's an in personam kind of a decision. So is it possible that an arbitral tribunal can be asked to decide on the validity of a patent, a biotech patent, for example? And interestingly enough, I think there have been a range of different views as to that, but by and large, the consensus has been that, well, as between the parties, it is certainly possible to have them decide a particular outcome, and they can and regard themselves as bound by that outcome. But legislatively, of course, we've had a few jurisdictions now try to address that issue specifically. And so, for example, in Singapore, we've recently had statutory amendments to recognize that IPR disputes and questions as to enforceability of a traditional patent or a trademark or infringement, subsistence, validity, ownership, scope, duration, all of those things that you would naturally assume to be what ordinarily would only have been something that a national court would have decided upon, is now expressly stated to be arbitrable as such. As between the parties, they are bound by the outcomes. And in Singapore, we also took pains to kind of make sure that that doesn't then affect, in turn, third parties that might be affected by those outcomes. So we have an explicit reservation, for example, to say that if there is a third-party licensee or a third-party holder of a security interest in that IP, then they are not bound by the outcome of this dispute. So it gives a very the reason why we've needed to go ahead and make a explicit statutory acknowledgement of this, I think it flows through from a wave of legislation that has been we've been seeing in multiple jurisdictions, because I think it recognizes this increasing recognition that arbitration and IP are not incompatible with each other. And in fact, there are tremendous benefits to this, which is that if you took the national court route to determining the outcome of validity of infringement, naturally you will find that the different national courts are going to have different outcomes. And when you start looking at the nature of IP disputes, you only would need to cast your mind back to a couple of years ago, where Apple and Samsung, for example, were having a patent war, right? Literally, Apple would sue for an infringement of a design patent, and then likewise Samsung would retaliate and say, well, you sue me for that. Well, by the way, you've also infringed these other rights. You have this issue of how, if you look at it from a global perspective, parties might be really litigating over the same set of rights, but facing the prospect that you're going to have a multiplicity of outcomes, which is a nightmare. And right now, I'm personally involved, for example, in exactly a brand dispute where we're having different outcomes in different national courts as to the rights that the parties respectively have to that brand. And this is where arbitration, interestingly enough, provides an opportunity to resolve this dispute as between the parties and on a global basis, because it avoids the prospect of different outcomes and trying to navigate that. So I think it's part and parcel of this recognition that has generally arisen, and I'm sure, Ignacio, your statistics would clearly demonstrate that increasingly people are starting to look at IP and arbitration as being the more appropriate way in some cases of resolving the disputes as between themselves. And I guess one more point in terms of a developmental thing, and indeed there was a question somebody has asked about, what about the role of the Singapore Mediation Convention? So I think that's a really important development, because the Singapore Convention, which is supposed to come into force, I think in September of this year, already you've got 50 plus states that have signed up to it, but it has the potential to be for mediation and for the settlement agreements that come out of mediation to have a clear framework for enforcement in the same way that the New York Convention addresses the issue of the recognition of arbitral awards. So it plugs this gap around how international mediation settlement agreements might be enforced and recognized by different party states. And I think all in this overall recognition that, well, when you resolve disputes, you don't necessarily have to go to the court system. You can allow for parties to try and resolve their disputes in a way that may be more efficient, or, for example, in a mediation settlement kind of a context, allows for the preservation of a commercial relationship. These are all very real considerations, I think, and the sorts of trends that we're seeing these days is a reflection of the increasing importance of how parties ought to be looking at resolving disputes.
Thank you very much, Yong-Yan, for your very comprehensive answer. If I may, just one point on the issue that you were raising about multiple court proceedings dealing with for instance, patent infringement, what we are seeing is, as I mentioned at the very beginning, an increasing number of cases where the issues are non-contractual disputes and where the parties may select one particular patent, the infringement relating to a particular patent, and as part of the autonomy of arbitration, submitting that issue to arbitration. And that's really one big advantage of arbitration. But Catherine, I think you should maybe comment a little bit on what Chung Niam just raised, and of course, if you feel like answering some of the questions that have been raised by the participants, please go ahead.
Okay, so we're getting short on time, so I'm going to try to address what I think are some of the more interesting and pointed questions on arbitrability, and I'm going to invite people. I think it seems we have to continue this conversation with the readings and maybe additional follow-up. I'm also having trouble seeing the questions, but a couple of things I want to highlight about non-arbitrability doctrine, which it's sometimes called. Arbitration agreements and arbitration awards do not need to be recognized and enforced if the subject matter of the arbitral dispute is non-arbitrable. And who gets to decide whether something's arbitrable or non-arbitrable? All countries of the world, all around the world. And that means that any particular dispute, one dispute, can nevertheless have multiple I'm getting some instructions here. So it can have multiple places. So for example, the most important place when you are choosing to try and arbitrate your patent dispute is you want to make sure that the legal seat where you are choosing to arbitrate has a law or judicial decisions that make patent disputes arbitrable. Now, one of the reasons why there is has historically been some reluctance, particularly with patent disputes, but IP generally, is that it tends to be a very highly regulated, oftentimes mandatory regime, right? Every country has statutes that create these rights, that create specific content about how you establish the right and how you can challenge the right, what kinds of defenses are available. And those are statutory provisions with elaborate national law. But the key to note is that even though you let these disputes go to arbitration, under the New York Convention and most domestic national law, legal errors by the arbitrators are not a basis for challenging an arbitral award. So that means you have this complex regulatory scheme that these states want to be enforced, but they cannot review the arbitrator's decisions on the substance. All they can do is essentially refuse to recognize and enforce an award if it violates public policy. And that is a very, very narrow threshold, a very difficult, precise way to try and protect detailed law on intellectual property. So you do need to check that you have arbitrability not only in the legal seat, but also other jurisdictions, okay? Because non-arbitrability is a very general way they can refuse to recognize and enforce an award. Once they let the issue, the intellectual property issue, go to arbitration, then even though they can have very sophisticated expert arbitrators, if they make an error, or for example, if they apply one jurisdiction's law when the courts of another jurisdiction are asked to enforce it, the courts are not generally allowed to review that substantively. So that's part of where I think tension in allowing arbitrability comes in, is to protect these sort of statutory regimes. Now, one of the ways, again, that I think that's counterbalanced, and we're almost out of time, so I'm going to turn to, this will be my last point, is the value of expertise. And particularly WIPO, I think, as an institution adds institutional expertise. But the difference between, particularly, for example, in the United States, having a judge who hears a criminal law case on Monday, a securities fraud case on Tuesday, and an intellectual property case on Wednesday, and has no intellectual property real expertise, when you choose international arbitration, you can actually select arbitrators who specialize in, have a deep understanding of the law of various regimes on intellectual property. And they combine that substantive expertise in intellectual property with a procedural expertise in managing international disputes. And that brings you, I think, a level of confidence in decision making and ability to tailor the dispute to the particular claims that is unique to international arbitration. So with that, because we're so short on time, I'm going to turn it back over to Ignacio to tell me whatever I missed, and also to probably add some insights from.
Thank you very much, Catherine. I think you're right. I think we're coming to the end of our time. Just one word on arbitrability. I mean, in our center experience, we don't see this as a practical issue, and what we see instead is really kind of practical ways of dealing with these. And of course, in a licensing context, parties are looking very often for inter partes effects. So I think maybe I'll stop at that. I just wanted to, while I'm still able to speak, I wanted to thank Catherine and Chung Niam, who, I mean, it's early in the US, it's very late in Singapore, and I wanted to thank them for all their preparation for this session. I see that there are quite a number of questions. I think we've answered some of the questions. There are materials that, as Javier was mentioning, will be posted and made available to the participants. And Laurent, I don't know if we still have time for a couple of extra answers to the questions. I'm under your control.
I think, yes, we do. We have time. We have due time for reply. We would finish as per traditional practice at 5:10 European time, which means 6 hours more in Singapore and 6 hours less in the UK. So basically, thanks to all our speakers and moderators for the great job. We have a few time for questions, which are posted on the chat, and for which you have already, for some of them, read them.
If I may, there's an interesting question about emerging technologies. Because of course what we are seeing constantly is new developments, whether it's online copyright or as Chung Niam was mentioning, the types of dispute between Apple and Samsung relating to patent standards. And I think I need to mention that Chung Niam is working on a report for WIPO at the moment on mobile apps and ADR, and perhaps maybe Chung Niam, if you want to mention a little bit what you're doing in relation to that report.
Sure, Ignacio. Thanks for that. Well, the report was was really trying to address the issue of relevance of ADR in the area of mobile telephony, and we are seeing apps taking over, frankly, the desktop, right? So many of us are, we probably hail from a generation where, yeah, we're accustomed to thinking about when we do serious work, we're using, first of all, a desktop machine, and then we've evolved into a laptop. But, you know, the smartphone has become so powerful that it is often being touted now as the replacement. And it's the next big thing, clearly. And the sorts of issues that are raised in that context are very interesting, because you have so much cross-border sorts of opportunities for interaction, both in terms of the users and also in terms of the developers. Today, a lot of development work that goes on behind the creation of IP that goes into mobile phone apps takes place all around the world. And in that kind of a context, for I think a number of the reasons that we just talked about, it is important for people to recognize that the ADR process gives some real opportunities for avoiding disputes that can end up being terrible to manage on a kind of a national court system framework. for some of the problems around the multiplicity of outcomes and so forth. And the study therefore examines the role of ADR, the applicability of ADR, the suitability of ADR to the sorts of disputes that you might find in this space. And of course, as I've mentioned, it could cut across so many things, the technology that goes into a phone, the sorts of media, content, the brands that you might be seeing in the applications, user-generated content that gets uploaded and used, so everybody talks about TikTok these days, right? But if you think about it, lots of IP issues. and also this rather important issue around FRAND licensing, the sorts of technology standards that might be applying in relation to some of the technology that's used on these platforms. So these are all very important questions, and I must thank also Ignacio an opportunity to talk about or to address some of these issues, and hopefully it turns out to be useful.
Thank you, Chungnam. Maybe if I can turn now to Catherine. Of course, these issues that we've been discussing, some are quite technical, but Catherine, I think you are working on, or you have developed, what do you call it? Legal tech startup dealing with arbitrators' intelligence. Do you want to talk a little bit about that?
I would welcome the opportunity. So I am an accidental legal tech entrepreneur. I had a research project that turned into a nonprofit, and then just this year we have it's turned into a legal tech startup. It's called Arbitrator Intelligence. I welcome you to our website, arbitratororintelligence.com. It aims to use legal tech to solve what is a very big problem in international arbitration. And let me summarize it this way. When you are looking for an international arbitration, you cannot just look up their track records because, as we've said, arbitral awards are all confidential, or mostly confidential. But you're choosing, you have a chance in most arbitrations to select one and usually have some input on the chairperson. So you can have input on two arbitrators. What you would want to know most before you appoint them is how have they decided disputes like mine in the past. But this information is not publicly available. So we have created an online platform that administers a detailed survey type instrument. We call it the Arbitrator Intelligence Questionnaire, or AIQ. And what it does is it collects all sorts of data about cases and the decision-making of arbitrators in past arbitrations, but while maintaining confidentiality. And with this data that we collect through the Arbitrator Intelligence Questionnaire, or AIQ, we produce arbitrator intelligence reports, which are individual reports on arbitrators and their track record. And the reason I think this is so important, it sort of brings us a little bit closer to this last issue that Ignacio previewed, which is green arbitration. I think green arbitration also ties in with questions about diversity in international arbitration. Historically, it's been a very closed community, a very Euro and US-centric community, because they were the first movers. But as we see the rise of disputes in places like Africa, Latin America, obviously Asia, we need to see more arbitrators who are also from those jurisdictions. But if you are trying to research arbitrators from across the world, it's very difficult. So arbitrator intelligence aims to resolve that problem, to make information about arbitrators, particularly information about newer and more diverse arbitrators, more available to everyone. And that, as I said, ties into this idea of greener arbitration, because arbitration, I think, especially as we're in an environment where all of our international institutions and even globalization itself is being challenged, I think international arbitration provides a glimmer of hope and excitement because it continues to thrive and even grow stronger in this environment. Even though it's very decentralized and sort of ad hoc, it is providing an incredibly important system of rule of law, and particularly for protecting intellectual property disputes. One of its, I would say, Achilles' heels in the past has been that it consumes a lot of energy because people were flying around to different places. not only for hearings, but also for lots and lots of conferences in international arbitration, which was how the community came together. But I think one silver lining in this COVID environment is that with the move online with hearings and also with arbitration, international arbitration meetings, we are seeing a very positive byproduct in that international arbitration among its various contributions is also making the world more environmentally friendly, or at least removing some of it, diminishing dramatically some of its carbon footprint.
Thank you very much, Catherine. I think, of course, it's extremely useful to have all this information available, and of course, one of the new matters that will become increasingly important as we have been discussing is also the fact of being comfortable with online case management tools and virtual hearings and for instance these green protocols that we are seeing are being developed at the moment make quite a few references to best practices and an attempt to reduce the carbon footprint of arbitration. And part of it is the type of meeting that we're having today now, instead of all of us having to travel to be together in, I don't know, wherever in Milan, maybe with Laurent. We are able to conduct this online, and what I find also extremely positive is to have. I was just checking the Q&A, but we have 23 questions really. So that's quite nice. We've tried to answer to quite a number of them, but I guess we need to stop now. But once again, thank you very much, Catherine, Chung Liam, Laurent, Javier. It's been a real pleasure to be here. Thank you.
Thank you very much.
Thank you for inviting me.
It's been a real pleasure for me as well, and thank you.
Thanks to all of you. I would wish to really very briefly conclude. All the questions that are on the chat will be published. We will reply.
Providing
Protocols that we are seeing.
Thanks to all.
But I guess
all the questions that
really. So that's quite nice. We've tried to answer to quite a number of them, but I guess we need to stop now. But once again, thank you very much, Catherine, Chung Liam, Laurent, Javier. It's been a real pleasure to be here. Thank you.
Thank you very much.
Thank you for inviting me.
It's been a real pleasure for me as well, and thank you.
Thanks to all of you. I would wish to really very briefly conclude. All the questions that are on the chat will be published. We will reply in the coming days to the questions, the various panelists, the two panelists, and also the moderator promised to do it. So I think this global digital encounter permitted really to enhance understanding of arbitration and mediation in the new context. And therefore, I think I'm really grateful to the three of you, to WIPO for its involvement, and to Professor Rogers, whom I didn't mention, but I should mention as well, teaches and has taught and will teach at Bocconi. And therefore, we are really, really proud to have such a brilliant team today. Our next encounter we will make no encounter in August. The next one will be in September. And the scoop is that it will be connected to artificial intelligence and software. As soon as we will have the detailed program that we keep for the time being, just for you to wait for, we will inform all of you via our traditional communication, emails and announcements. But before closing this event, I noted that we practically have exactly the same number of attendees at the start, during and at the end of the event. This is something which means that our speakers were, as we organizers already knew, super brilliant and efficient, as well as our moderator. I warmly thank also our partner in organizing and our key organizer, Fide Foundation, and in particular, Javier Fernandez-Taschetti, who helps us so much and run so much in a team this activity jointly with my colleague and friend, Professor Manuel de Santes, who is also in the think tank and is a key player in this activity. So to all of you, for those who are in continents where there is summertime and in continents where summer this very can be a bit enjoyed, I wouldn't say fully enjoyed, I wish all of you a nice summer period, and we keep in touch even during this period through replying to your questions. Everything, all what we have done today will be posted, and again, all questions will be replied to directly to each participant. Thank you, and have a nice summer to all.
Thank you.
Thank you. Bye-bye.
Thanks. Bye-bye.
Bye-bye.